Hearing in the appeal, Volcafe Limited and others against CSAV.
Mr. Russell.
May it please your lordships, in this matter I appear on behalf of the cargo claimants with my learned friend Mr. Coffer, my friends Mr. Rainey and Mr. Seamark appear on behalf of the carrier CSAV. In terms of the timings, we've agreed that I should have this morning and until 2:30 this afternoon. Mr. Rainey will then have the rest of the afternoon and tomorrow morning until 12:30, and I'll have half an hour in reply at the end. My lords, you'll have seen from the papers, obviously, that this case concerns the carriage of coffee from South America to Northern Europe in the Northern European winter, and in particular the dressing and the lining of the containers. Before I turn to the issues, I thought it might be helpful to show you very briefly a short sequence of photographs just to put in factual context what we're talking about here. And we can pick that up in volume 5 of the appendix. At tab 2.
Before we get to tab 2, can I ask whether there is somewhere in the bundle or can be provided a legible copy of the contract that we're talking about?
Yes, I think we've got more legible copies, and I'm sure that those are passed out.
I can't read any of the bits that matter.
Yes, and I'm afraid the photocopying has not gone well in relation to that tab. So the sequence of photographs that I was going to take you to, tab 2, page 1069. And these are photographs from the load port, and they focus on one container, and they're helpfully time-stamped so that we can see the history of this particular container at the load port. So at page 1069, we see the empty container at 8:05, and at 1070, the door has been opened to reveal the empty container, again at 8:05. And then we can see on 1071 that the dressing or the lining of the container has taken place and seems to have been completed by 0840, looking at the timestamp. And you can see that paper has been taped to the side walls and suspended from the ceiling of the container by string. And there's another shot of that with the door closed at page 1072. And then at 1073 and 1074, you can see that the bags of coffee have been loaded into the dressed or lined container. And obviously, in terms of factual analysis of the trial, the principal issue was whether the lining or the dressing of the containers had been done properly and carefully by the carrier, or whether, and notwithstanding that, damage had occurred, or whether the dressing had not been done properly and carefully. So turning to the issues in the case, there are obviously a variety of ways in which one can slice up the issues. What I propose to do is address you by reference to 3 broad topics. First, what proof of damage achieves in a contract of carriage to which the Hague rules apply. Does it impose a legal burden on the carrier to exculpate itself, either by proving that it exercised the contractual degree of care or that a contractual defence applies? Or does proof of damage merely give rise to an inference that the carrier might be in breach of contract, with the legal burden of proof remaining on the cargo claimants to prove a breach of Article 3.2? Secondly, I'm going to turn to the question of the inherent vice defence itself and analyse what a carrier has to prove to be able to rely on that defence. And then thirdly, I'll look at the correct outcome of the facts, if our arguments on the law are accepted. So turning immediately to the first of those issues, and this is the first real battleground in the case, the issue is what proof of damage achieves in a contract of carriage which incorporates the Hague Rules. Now, I take this first because, as a matter of analysis, logically, it's the first step in the analysis. This point arises before this court, essentially by way of cross-appeal by the carriers, because we say the Court of Appeal decided at this point in our favour. And the heart of the dispute turns on two linked points, as I say, the effect of proof of damage during the currency of a bailment on Hague Rules terms, and the rule of Article 3.2 of the Hague Rules. The carrier's case is that there is a legal burden on the cargo claimants to prove a breach of Article 3, Rule 2, and that cargo cannot succeed in any case unless it satisfies the court on the balance of probabilities that the carrier has failed properly and carefully to care for the cargo. Proof of damage does no more than raise an inference, an evidential inference of breach, and that inference can be defeated by the carrier adducing some evidence that an exception applies or that it wasn't negligent, without the carrier having to prove either of those two matters on the balance of probabilities. By contrast, our case is that the purpose of Article 3, Rule 2 is to define the standard of care that's required of the carrier, but a contract of carriage is a contract incorporating the Hague Rules is still a contract of bailment, and that the bailment burden of proof applies, so that if cargo proves that the cargo is damaged during the bailment, then on standard bailment principles, there's a legal burden on the carrier either to prove on the balance of probabilities that it provided the contractual standard of care, or to prove on the balance of probabilities that one of the contractual exceptions applies in the case. Now, if I can take you to the Court of Appeal's decision on this issue, we say that the issue is clearly decided in our favour. There's a faint suggestion in Malone Friend's written case that the Court of Appeal didn't decide this point in the way in which we say it was decided. That's at paragraphs 13, then 109 to 110 of the written case. But we say if we look at the relevant paragraphs of the judgment, it's clear that the Court of Appeal decided it in our favour and adopted a legal burden of proof approach. It's paragraphs 35 and 36 of the judgment. The judgment is in the main appeals bundle at page 217 on the memory stick, and it's paragraphs 35 and 36 of the judgment. Mr. Justice Flo, giving the judgment to the court, said in terms in paragraph 35, about 6 lines down, as to whether the burden of proof at the first and second stages is a legal burden on the cargo claimant to prove delivery in a damaged condition or non-delivery, and then a legal burden on the carrier to establish the operation of one of the Article 4, Rule 2 exceptions, or merely in each case an evidential burden, I consider that the better view is that in each case the burden is a legal one. And then he explains that by reference to the Flowergate and the Torinia. And then similarly in paragraph 36, 5 or 6 lines down, once the cargo claimant demonstrates non-delivery or delivery in a damaged condition, he has, as Mr. Justice Hophouse says, set up a sustainable cause of action. It's then for the carrier to explain what happened to the goods whilst they're in his care, and if he can put forward no explanation, then the claim will almost certainly succeed. If the explanation advanced by the carrier involves the invocation of one or more of the exceptions, Mr. Bryan's second stage is reached, and the legal burden of proof is on the carrier to establish that the exception applies. Now, we say that the carrier's argument in this case is wrong. The essence of the carrier's argument is that a bailment on the Hague Rules terms is materially different from a common law bailment. They accept our analysis of a common law bailment, which is that there is a legal burden of the nature that I have described on the bailee once proof of damage is established. But they say that the position is quite different under the the Hague Rules terms and a contract of carriage into which those rules are incorporated. We say that the carrier's argument is wrong for 4 principal reasons. First, there is nothing in the Hague Rules which ousts the bailie's common law obligation to redeliver in sound condition. Secondly, the carrier's attempt to draw a distinction between a strict obligation to redeliver in sound condition at common law and the obligations under the Hague Rules creates a false dichotomy. Thirdly, we say that in any event, the bailment burden of proof does not arise, or certainly arise solely, from the obligation to redeliver in sound condition. It's broader than that, the principle underlying the burden of proof. The law puts the burden on the bailee to exculpate himself because of his special position on the facts. He knows all about what has happened, or at least is likely to be in a much better position than the bailor to know what has happened. And the burden of proof has been described in the cases as a matter of both justice and common sense, and I'll take you to the relevant authorities in a moment. And therefore, the bailment burden of proof should continue to apply in a Hague Rules bailment, even if the carrier is right at the earlier stages of the argument and there's no obligation to redeliver in sound condition. And fourthly, we say that since the rules were passed and became a feature of English law in 1924, the cases have proceeded consistently on the basis that the bailment burden of proof continues to apply.
I'm just wondering, your argument really seems to be placing a lot of weight on the fact that the relationship is contractual.
Yes.
And the force of the Hague Rules derives from their incorporation as contract terms.
Yes.
Would the position be different under the Hague-Visby rules?
It wouldn't, because the rules still apply to a contract of carriage, which is a contract of bailment. So whether it's the Hague Rules incorporated by contract or the Hague-Visby rules having the force of law, the underlying principle still remains that it is a contract of carriage and a contract of bailment to which the rules attach, either by incorporation or by force of law.
It's one of the points being made against you is that this is a rather Anglo-centric approach.
Yes.
And that the Hague Rules are intended to have the same effect internationally.
Yes.
Now, the English law of bailment doesn't apply even north of the border.
Yes.
But
My friend, Your Lordship, has the advantage of me there.
But there's an equally strict liability at common law there on a civilian basis, which would be shared, I think, with most continental systems. But I'm wondering if any, it's not apparent from the cases, but I'm wondering if any thought has been given to how this sort of issue would be looked at in non-English legal systems.
There's no materials in relation to that before the court. There was some discussion on this very point that's reflected in the Travaux Préparatoires. And the gist of it is that the drafters sought to adopt a draft which would achieve the same result, notwithstanding the fact that different legal systems were coming at it from different angles.
Can I suggest to both parties, but I suspect this is probably principally directed at Mr. Rainey, that it might be helpful if they looked at the way that the Hague Rules have been incorporated in other jurisdictions, in particular in civil law jurisdictions. I mean, the US Act is effectively, for purposes so far relevant to this issue, copied out of the Carriage of Goods by Sea Act 1924. But I can't find a single European jurisdiction in which liability is not strict, subject to the exceptions. I mean, you might find it helpful to look at, in France, the Code des Transports, Article 5422/12. In Germany, the Handelsgesetzbuch, Article 498, sub 1. In Italy, the Codice della Navigazione, Article 421. They all impose strict liability, subject to proof that the exceptions apply.
Yes. It certainly seems to, I mean, we've set out a short analysis of the Travaux in the appendix to our written case, and certainly, while one struggles to find, as one often does when one looks at the Travaux, a single passage that encapsulates the point that one's looking for, I mean, we say that the general theme that suffuses the Travaux, and which is with respect adopted in most jurisdictions, is one of strict liability.
The reason why one would expect to find that is that in both of the two great families of law, namely civil law and common law, the rule about bailment, including bailment, strict liability is subject to exceptions specified by law.
Yes, yes. Indeed, I think I'm right in saying in both broad families, stemming back to Roman law considerations. Yes.
Well, we flagged up this point at a very early stage in the hearing.
Yes.
To enable parties to reflect on it. If you wish to put in further written submissions on this point, and you may feel that would be helpful, then obviously you can make an application to us and we can decide what to do about that.
Yes, well, certainly we have Your Lordship's indication that Your Lordship might benefit from that.
Yes.
So we certainly look at that and see if we can reach some agreement in relation to that. So my first point is that there is nothing in the rules to oust, certainly at common law, the obligation or the burden of proof which was on the carrier or the bailee. As I say, we say that looking at it in the context of a common law case, the question of burden of proof is a question of the construction of a contract of bailment into which the Hague Rules have been incorporated. And the rules are not, first of all, they're not an exhaustive code, and secondly, they do not fall to be construed in a vacuum. There's nothing in the rules themselves to the effect that they're intended to be an exhaustive code covering all aspects of the contract or all aspects of the bailment. And even a fairly cursory reading of the rules makes it clear that they're not an exhaustive code. The rules are set out in the schedule to the 1924 Act, which we've included at tab 1 of the authorities volumes. It's MS 1298, with the rules themselves appearing 1299.
Beg your pardon, which
So this is the authorities, volume 1, part 1.
yeah, thank you.
And the electronic reference is 1299. And perhaps most strikingly, in the context of the current debate, the rules don't impose any express obligation on the carrier to redeliver the goods at all. Nor, for example, is there any obligation to redeliver to the named consignee or the lawful holder of the bill of lading. The operations that are covered by the rules are those identified in Articles 2 and Article 3, Rule 2, and they end at discharge, the so-called tackle-to-tackle coverage of the rules. But plainly, in many cases, the goods will not be redelivered on discharge. Redelivery will take place after discharge, and the rules are silent as to that. And indeed, as the carrier has pointed out in this case, as a matter of English law, perhaps rather surprisingly given the wording of the rules, the carrier isn't even bound to perform the functions that are set out in Articles 2 and Article Rule 3.2, English law has proceeded on the basis that those rules define the standard to which the carrier must perform functions which it contractually undertakes, but the carrier is entitled to contract out of the performance of those functions. See the Jordan 2. So plainly, it can't be said that the carrier isn't under an obligation to redeliver and to redeliver to the right person at all. And therefore, it has to be the case that the underlying or pre-existing obligations of a bailee to redeliver have to be either read into the rules or simply treated as continuing to exist as part of the contract of carriage and the contract of bailment. And there's nothing in the rules which prevents the obligation on the carrier being the ordinary common law obligation to redeliver in signed condition. What we say Rule 3.2 does is to set out the standard of care that applies in a Hague Rules bailment, and that can be compared with the common law standard, which was simply one of reasonable care. If the goods are not redelivered in a signed condition, the carrier can exculpate himself by proving that he exercised the appropriate standard of care, reasonable care in a common law bailment case, or the Article 3 Rule 2 standard of care in a Hague Rules case. And we say that the textbooks and the authorities support this analysis, that one does not approach the construction of a Hague Rules bailment case in a vacuum without reference to the underlying bailment obligations. If I could take you just to a couple of passages to make that good. First of all, in Palmer, in volume 6 of the authorities, at tab 90, and the electronic reference is 3465. Paragraph 20.016. Second paragraph, Palmer says, subject to any express term in the contract of carriage to the contrary, common law obligations arising from the bailment itself will subsist. Common law imposes on the bailee for reward an obligation to use according to the terms of the contract. And then discussing the duty of care, there's no suggestion that the ordinary common law approach to burden of proof does not continue to apply in a Hague Rules case. So towards the end of paragraph 20.017, the authors say, thirdly, there's a fundamental principle of the law of bailment. If the goods bailed are lost or damaged, the burden of disproving breach of the requisite duty of care lies on the bailee. And as I say, no suggestion that the position is any different under the rules. And then, to similar effect, the judgment of Mr. Justice Hobhouse in the Torinia case, which is in the Authorities, volume 1.2, at tab 20, the electronic reference is 1766. At pages 214 through to 219, there's a careful analysis of the law relating to burden of proof generally in a Hague Rules case. And specifically on this point that one doesn't look at the rules in a vacuum, one can pick it up in the left-hand column page 216. Justice Hobhouse says the relationship between the present parties is contractual. It follows, as was accepted by both counsel, that the question of legal burden of proof has ultimately to be decided by construing the contract between them. Cases such as the Glendarach were decided as a matter of construction of the contract before the court, albeit approaching the question of construction by having clearly in mind the legal and historical background to such contract. In ascertaining the effect of the contract, one must take into account the nature of the contract. The contract here is a contract on a bill of lading. It's a contract of carriage, that is to say, a species of a contract of bailment. And then, in the right-hand column on the same page, the first full paragraph at the top of the right-hand column, it's only because the contract in this case is a contract of bailment that the plaintiff sets up a sustainable cause of action by proving the non-delivery of the goods. It's then for the defendants to set up a sustainable defence. I use the word sustainable in preference to prima facie, since prima facie is frequently used to refer to a case which shifts the evidential burden of proof rather than giving rise to a legal burden of proof in the opposite party in the manner that I've explained above. My Lord,
So why is he saying sustainable defence? Why is he not saying it's then for the defendants to set up a defence? What lesser sort of defence is he talking about, Mr. Russell?
Lord, I wouldn't accept that by saying sustainable defence. He is suggesting any lesser standard than a proof of the defence on the balance of probabilities.
I see.
He's drawing a distinction between, in both cases, a sustainable cause of action and a sustainable defence. And
Your submission is it means a good defence.
It's good defence, yes. It's a difference between that and an evidential seesaw, so that the defence will be good unless at a third stage there is an exception to the defence or some other level of proof that makes it bad. So proof of damage sets up a sustainable cause of action, meaning a good cause of action. The carrier will win. I beg your pardon, the cargo claimant will win.
Will win unless the carrier establishes his case on balance of probabilities.
On balance of probabilities.
And that's what the passage is looking at. It's distinguishing a prima facie case on the one hand,
Yes.
which might affect the evidential burden, and the establishment on balance of probabilities of the defence itself.
Exactly so. And also, if I may say so, laying down quite an important warning marker, which is that when one looks at some of the authorities, the term prima facie is used, but in context plainly means what Mr. Justice Hobhouse means by sustainable and a good cause of action and defence. So when one sees the use of the words prima facie in this context, one has to look carefully at what in fact is being said to see whether they're being used in the sense of merely shifting the evidential burden, or whether in truth they are being used to reflect a legal burden. Prima facie, in that sense, being used to say, so, at the first stage, cargo has established a good cause of action, subject to the carrier being able to prove on the balance of probabilities a defence, either that it's exercised the degree of contractual care that's required, or that a contractual exception applies.
Is this decision the origin of the use of the term sustainable in this context?
I think it is. I'm not sure that there is an earlier decision that uses that terminology. And we have here quite a detailed analysis of the burden of proof. So obviously one of the features of so many of these cases is that burden of proof will be addressed in passing or somewhat tangentially, because in most cases the facts are decided. It's a relatively small handful of cases, including, of course, the one before the court today, in which statements in relation to burden of proof are actually part of the ratio rather than simply being obiter. So in relation to not construing the rules in a vacuum and the relevance of pre-existing law, there are passages to the same effect in the High Court of Australia decision in Gamlin. I'll give you the reference to that, but it's probably not necessary to turn it up. The passages are at electronic reference 3225. The court observed that the rules were part of an international convention, but then it indicated that it was still appropriate to have recourse to the antecedent municipal law of the nations, and it would be extremely difficult to interpret the rules in a vacuum. And then, I think finally on this topic, Lord Staines's speech in the Giannis NK case, which is in the third volume of the authorities, tab 41, picking it up at electronic reference 2310. I beg your pardon, the case starts at 2310. The relevant passages start at 2326, which is internal 621. At the foot of the page, Lord Steen says, "This much we know about the broad objective of the Hague Rules. It was intended to rein in the unbridled freedom of contract of owners, to impose terms which are so unreasonable and unjust in their terms as to exempt from almost every conceivable risk and responsibility, and it aimed to achieve this by a pragmatic compromise between the interests of owners and shippers. And the Hague Rules were designed to achieve a part harmonisation of the diverse laws of trading nations, at least in the areas which the Convention covered." In my submission, that supports the analysis that the rules weren't intended to be a complete or exhaustive code covering all aspects of the contractual or bailment relationship. As Lord Steen says, they sought to achieve a part harmonisation in relation to the areas in which they covered. And then at page 624 and 625, it's putting letters F to G on 624 and C to G on 625. In summary, what Lord Steen says is that the part of the contextual consideration when considering the rules is the pre-existing legal position, and particularly where there was a dominant theory, in this case as to liability of a shipper for shipping dangerous goods. That dominant theory was a circumstance which must have been known to those who drafted and approved the rules, and it can be supposed that if the intention of the drafters was to change a dominant theory, that would appear clearly either in the rules themselves and or in the travaux. And we say that's relevant in this case because contracts of carriage have always been seen as contracts of bailment, and the bailment burden of proof is very well established as a matter of English law. And if it was intended to introduce a radical departure from the bailment burden of proof, with the legal burden being on the carrier to exculpate himself, that is something that one would have expected to have seen reflected very clearly in the drafting of the rules.
And the dominant theory referred to between C and D on 625 was that shippers were under an absolute liability not to ship dangerous goods.
Yes.
Which is a different kettle of fish.
It's a quite different dominant theory, yes. It's looking at a different aspect of the rules, but my submission, the same principle holds good. Just as Lord Steen says that if the drafters of the rules had intended to displace that dominant theory, so had they intended to displace the dominant theory in relation to burden of proof placed on a bailee, so you would expect to see that reflected in clear wording in the rules. I quite accept that this is a different subject matter,
yeah.
But the principle holds good. Now, if we turn to the rules themselves, we say that there is, and again, those are in the appeal documents bundle. I beg your pardon, they're not. They're in the first authorities bundle. Have one. There's nothing in the rules which is apt to oust the obligation to redeliver in sound condition or displace the bailment burden of proof. We say that the way in which the Hague Rules modify the common law bailment regime for present purposes is that Article 3 modifies the standard of care which the bailee is required to provide. So rather than having a standard of care which is reasonable care simpliciter, one has the more elaborate standard of care set out in Article 3, Rule 2, which then is made expressly subject to the 4.2 defences. The introduction of a different standard of care does not necessitate or in any way imply a change to the common law obligations in relation to the obligation to redeliver the goods in sound condition, and in relation to the burden of proof. And as we'll develop in the next section, the common law obligation to redeliver in sound condition was always subject to proof by the bailee that he had taken reasonable care. Consistently with that approach, the obligation to redeliver in sound condition under the rules can be seen as being subject to proof that the carrier has complied with the Article 3, Rule 2 standard of care, or proof that one of the exceptions applies. And then finally, in relation to this point, where the rules themselves deal with burden of proof, they're entirely consistent with the bailment burden. In Article 4, Rule 1, and Article 4.2q, where the rules touch on the burden of proof in relation to the carrier proving due diligence, or proving that the loss was caused without his fault, the burden of proof is expressly put on the carrier. Far from there being anything in the rules which is inconsistent with the bailment burden of proof or ousts that burden, the rules are expressly consistent with it. Further, looking at the rules, the carrier's analysis in this case, that really there's simply an evidential seesaw with the legal burden being on the cargo claimants throughout to prove a breach of Article 3.2, isn't consistent with the scheme of the rules. If the position was that there was always a legal burden on the cargo claimants to prove breach of Article 3, Rule 2, it simply wouldn't be necessary to enumerate a list of exceptions, because at the evidential level, whether the exceptions are there or not in the rules, the carrier would be able to say, I can defeat the inference that I was negligent because the cause was due to an act of God or a strike or civil commotion or whatever. I therefore shift the evidential seesaw back to you to prove that I was in fact negligent. Having a list of enumerated exceptions only makes sense if there is a sustainable cause of action established by proof of damage, putting a legal burden on the carrier to prove certain matters. And that is most starkly brought into focus by exception Q. Because there can't be a legal burden on the cargo claimants to prove breach of Article 3, Rule 2, that is in any way consistent with Q being an exception. Because if at the first stage the cargo claimant has to prove that the carrier was negligent, or there's a breach properly and carefully to carry, you would never get to a stage, as a matter of legal burden, where the carrier had to prove that he had not been negligent or his servants had not been negligent. So the list of exceptions generally, but in most particularly Q, only stands if there is a legal burden imposed on the carrier by proof of damage by the cargo claimants. Now, the second main point that I wish to develop on this topic is that the carrier in this case attempts to draw a false dichotomy between what it terms a strict obligation of common law and the position under the Hague Rules. And again, to recap, that the relevant principles of a common law bailment, which are accepted by CSAV, are that the bailee is under a duty to take reasonable care to prevent damage to the bailed goods. The bailee is under a duty to redeliver the goods in sound condition in accordance with the terms of the bailment, and that proof of damage during the currency of the bailment puts a legal burden on the bailee, either to prove that the damage occurred without any failure to take reasonable care, or to prove that he can rely on a contractual exception. That's all common ground. What the carrier seeks to do by the second and third propositions in their written case is draw a contrast between, they say, what's a strict obligation under the common law of bailment to redeliver the goods in the same condition, and the Hague Rule obligation in Rule 3.2, properly and carefully to care for the cargo. And they say that there is no obligation under the Hague Rules corresponding to the strict common law bailment obligation. But as I said at the outset, that's a false dichotomy, in that there is no such strict common law bailment obligation in the sense that the carrier contends for, because the common law bailment obligation to redeliver in sound condition was always qualified by the bailee's ability to exculpate itself by proof that he took reasonable care of the goods. So there was always that qualification, in the same way as the obligation under the Hague Rules to redeliver in sound condition is qualified by the Article 3, Rule 2 standard of care. But the point is that a failure to redeliver in a sound condition puts the burden of proof of exculpation on the bailee. One can see this in the, I mean, it's fairly trite stuff. One can see it in Chitty, in the authorities bundle at bundle 6, tab 85. The electronic reference is 3361. Custody for reward is discussed at 33049, and then the onus of proof and scope of the duty at 33050. The loss of or injury to the chattel while in the bailee's possession places the onus of proof on the bailee to show that it was not caused by any failure on his part to take reasonable care, but he need not show exactly how the loss or injury occurred. So, yes, there's an obligation to redeliver in sound condition, but it's qualified by the bailee being able to exculpate himself by showing that he has exercised the degree of care required by the bailment. Similarly, in Palmer, which is in the same volume of the authorities at tab 90, the electronic reference is 3418. it's quite a lengthy analysis, but the primary duty is analysed as being the duty of care. And if the goods are not redelivered in a signed condition, again, the bailee can exculpate himself by demonstrating that reasonable care has been provided.
This part of your argument is not disputed.
Well,
Apart from the Hague rules, I think it's accepted that there would be strict liability and the burden of proving, carrier would have the burden to prove an exception applied.
yes, what my friend seeks to do is, as I say, in his case, particularly propositions 2 and 3, is to draw a distinction between what he terms a strict obligation at common law and a different obligation under the Hague rules. And I may be taking a sledgehammer to a nut here. The point that I make is that in both contexts, the obligation to redeliver in a signed condition is qualified in the same sense that the bailee or the carrier can exculpate himself by proving that he has provided the requisite degree of care that's required either by the common law embellment or the contractual terms. So the dichotomy that carrier seems to rely on is, we say, a false dichotomy. I'll move on to the third point, which is that in any event, the authorities show that the bailment rule as to burden of proof doesn't depend on the nature, or certainly doesn't depend solely on the nature of the delivery obligation. There are wider principles underlying the bailment burden of proof. If I could take you to the case of the Rapahu, which is in Authorities Volume 5. It's tab 69. And the relevant passage is at 3055. This is a case in which a ship was bailed to ship repairs. But the position was slightly unusual in that the repairers' men were present during the day, whereas the ship owners' men were present in the evening when the repairers knocked off. The crew were left on board. And it was held that it was a contract of bailment, but that somewhat unusual fact had an impact on the burden of proof. The relevant passage starts at electronic reference 3055 in the left-hand column, halfway down, where the judge says that he is going to consider the burden of proof. He discusses a pure bailment case. And when he says pure bailment case there, he is contrasting the case where the bailee has exclusive possession of the chattel with this slightly unusual case where the bailee's men were only present for part of the time and the bailor's men were present for the rest. And he sets out a fairly standard analysis. But then at the bottom of the right-hand column on that page, he says, how far is the position altered by the presence of the owner's servants? I do not think that the rights reserved to the owners to retain the use of the vessel for certain purposes prevents the transaction from being one of bailment, but I think that the principle of onus of proof must in such a case be modified, though not destroyed. And then this is the point on which I rely. The original principle seems to be grounded on a common sense view of the facts. The bailee knows all about it. He must explain. He and his servants are the persons in charge. The bailor has no opportunity of knowing what happened. These considerations, coupled with the duty to take care, result in the obligation on the bailee to show that the duty has been discharged. He then goes on to discuss how that principle means that the burden of proof is modified on the facts of the case. So what we see there is that the underlying principle behind the bailment burden of proof is not seen as turning on the nature of the redelivery obligation, but a more fundamental principle that because of the bailee's special position, he should bear the burden of proof. And then, to broadly similar effect, in the case of BRS and Crutchley, which is in the second volume of Authorities, at tab 32, there's a passage in the judgment of Lord Justice Sachs at electronic reference 2103, where he says at the foot of the right-hand column, again discussing the bailment burden of proof, common law has always been vigilant in the interests of bailors whose goods are not returned to them by the bailee for a number of reasons. Insofar as that vigilance relates to the onus of proof, one of the reasons stems from the fact that normally it's only the bailee who knows what care was being taken of the goods, and another from the number of temptations to which a bailee may succumb. And he goes on to discuss those temptations. Again, we see that here the underlying principle behind the bailment burden of proof is being analysed in broader terms than simply an obligation to redeliver. And there are passages to the same effect in the Levinson and Steam Carpet Company case, which is in Volume 1, Part 2 of the Authorities, at tab 14. This is a case in which a fine Chinese carpet had been bailed to be cleaned. The cleaners sought to rely on a combination of terms which would have limited their liability to £40. And the claimant, the plaintiff, pleaded by way of reply that the bailee could not rely on the contractual exclusion terms on the grounds of fundamental breach. Now, obviously, the doctrine of fundamental breach is no longer good law. But the principles underlying the analysis of burden of proof, in my submission, hold good. And the decision of the Court of Appeal was that although it was the plaintiff who had pleaded fundamental breach by way of reply, nonetheless, the burden remained on the bailee to prove that the loss had not been caused by a fundamental breach, thus entitling the bailee to rely on the contractual exclusion and limitation clauses.
The logic is somewhat different in a fundamental breach case, because the notion of fundamental breach was that it discharged so that there were no exceptions to be relied on.
Yes.
I'm not sure that that's the same issue as the one we're concerned with. I mean, you're entitled to say that if they applied it in the context of fundamental breach, a fortiori. This is right.
Yes. It is a different context. The 2 points that I draw from the case are, firstly, that the broader, we might say, policy reasons for putting the burden on the bailee are set out in similar terms to the two cases that I've taken your lordships to. In other words, it's because the bailee is in the position to know that the burden is on the bailee. And secondly, although it was the plaintiff who pleaded fundamental breach as a way of ousting the contractual exceptions, and therefore on a he who pleads must prove analysis, it might have been said that the burden was on the plaintiff to prove that it was fundamental breach. The strict pleading approach to burden of proof in the bailment context was not followed, and it was held that the bailee had to disprove that the breach was a fundamental breach to be enabled to rely on the contractual exceptions. Sorry,
In reality, it follows, doesn't it, that there was no need, this is correct, for the point to be raised by the claimant by way of reply.
well, that's one way of looking at it. The other is that it has to be raised as an issue and it is required to be pleaded. And but once it has been pleaded, the burden, despite that pleading analysis, is placed on the other party. It's certainly not the usual approach. I fully accept it's not the usual approach adopted by English law as to where the burden lies. But that is the principle I draw from the case. In the bailment context, it does not necessarily follow that he who pleads must prove. Lord, the passages that we rely on, I think, are set out in our case, in the judgment of Lord Denning. It's at 1672 H to the end. And then in the judgment of Lord Justice Orr, page 1674 at C, he says, on the final and crucial issues of the burden of proof, I agree that that as a matter of both justice and of common sense, the burden ought to rest on the bailee, who, if the goods have been lost while in his possession, is both likely to know the facts and be in a better position to ascertain them than the bailor. So, again, not analysing the burden of proof by reference to he who pleads must prove, but by reference to a broader principle of justice and common sense. Lords, the fourth point that we make then in support of our analysis of the burden of proof is that since the introduction of the Hague Rules into English law, the courts have consistently proceeded on the basis that the bailment approach to burden of proof continues to apply even under the rules. The starting point is the judgment of Mr. Justice Wright in the Goss-Millard case, which is in the first volume of Authorities, Part 1. At tab 9. And he notes at the top of 1542 that in relation, there were two claims. In relation to one of the claimants, the precise cause of the damage hadn't been ascertained. He said it makes it necessary for me to determine as a matter of law on whom the onus of proof lies. And at the foot of 1542, he says the carrier's failure so as to deliver must constitute a prima facie breach of his obligations, casting on him the onus to excuse that breach. I mentioned earlier the warning marker of Mr. Justice Hobhouse in the Terrania case, that one has to be careful when one sees prima facie used. In my submission, it's clear in context that here, where Mr. Justice Wright says constitutes a prima facie breach, he's not talking about an evidential burden. He is talking about a legal burden being discharged, creating a good or sustainable cause of action, casting a legal onus on the carrier to excuse that breach. He goes on in similar terms. And he draws an analogy to the general rule applicable in bailment at the top of 1544. And then at the foot of 1544 notes that Article 4, Rule 2Q expressly lays down the same burden of proof. So from the outset, the burden of proof under the rules is analysed as being the bailment burden of proof. And there were other early cases which are consistent with that. I've put into the supplemental volume of authorities Payne and Ocean Steamship, which make the same point. I don't need to take you to that. If I can then take you to the Silver Ocean case, which is in tab 5, volume 5 of the authorities. It's tab 71. This is a case which involved the carriage of frozen Chinese eggs, which had been damaged at various stages in transit. And it's right that the principal issue was the effect of the rubric received in apparent good order and condition on the bill of lading, and the extent to which that created an estoppel in the case. But there are very clear statements as to the continued applicability of the bailment approach to burden of proof. If one looks at electronic reference 3094, Lord Justice Scrutton says, first, under the law prior to the carriage of goods by sea Act 1924, a ship owner who received goods which he signed for in apparent good order and condition to be delivered in like good order and condition, and who delivered them not in apparent good order and condition, had the burden of proving exceptions which protected him for the damage found. The present bill of lading runs shipped in apparent good order and condition for delivery subject to conditions. Has any difference been made in the old law by this wording? In my opinion, no difference has been made. I agree with the view expressed by Mr. Justice Wright on similar words that there's still an obligation to deliver in the like apparent good order and condition unless the ship owner proves facts bringing him within an exception covering him. And he refers to Bradley and Federal Steamship Navigation, which, it's right, wasn't a Hague Rules case, but it applied the perfectly normal bailment burden of proof approach. And plainly, Lord Justice Scrutton is of the view that that applies also in a Hague Rules case. And similarly, electronic reference 3109, in the judgment of Lord Justice Slessor, top of the page, he says, here the rules in the schedule to the Carriage of Goods Act are incorporated, the wording of which statute does not affect the old principle, per Lord Sumner in Bradley and Federal Steam Navigation. And the old principle that was set out by Lord Sumner in that case is again the bailment burden of proof. So Lord Justice Slessor also saying that the introduction of the rules makes no difference to the bailment of proof issue. The next case is Leash River T, which is in volume 4 of the authorities. It's tab 52. This was a case in which the issue was whether the owners could rely on the 4.2q exception, where stevedores had stolen a brass plate covering a storm valve, which allowed water to enter the holds and damage the cargo. And the decision was that because the removal of the plate was so out with the scope of the stevedores' engagement, that the owners weren't responsible for it. The stealing of the plate wasn't an act of servants or agents of the carrier for the purposes of the exception. But what matters for present purposes is that it was treated as really axiomatic that the delivery of the damaged goods, or the goods in damaged condition, meant that the carrier would be liable unless he could bring himself within the scope of one of the exceptions. And you can see that at electronic reference 2563. Where Lord Justice Sellers said that the ship owners who now appeal against the judgment of Mr. Justice McNair, holding them liable, recognise that they failed to deliver the goods in question in the same good order as they received them, and that they are liable for the damage sustained unless they can bring themselves within the rules. Now, what my learned friend says is, well, that's merely the judgment recording a concession that's been made, and therefore you can't really attach any weight to it. In my submission, it goes substantially further than that. It's not a question of Lord Justice Sellers merely recording a concession. He's obviously treating it as plainly correct and treating it as I say, as axiomatic that even in a case to which the rules apply, where the goods are not redelivered in a sound condition, the bailment burden of proof applies, and the burden is on the carrier to exculpate himself. The same effect. There's the Flowergate, which is in Volume 1, Part 1 of the authorities. It's at tab 6. Pages 6 and 7 of the report, electronic references 1431 and 1432. There's a discussion at the bottom of the right-hand column on page 6, running over to the left-hand column on page 7 of the defences that the carrier was seeking to run, including an inherent perils of the sea defence and inherent vice defence and catch-all and Q. Having discussed the defences, Mr. Justice Roskill says halfway down the left-hand column on 7 that the burden of proof rests upon the defendants to establish the defence of inherent vice admits of no doubt. Again, where do we find that? I'm so sorry, it's page 7, left-hand column, about halfway down the page. Lords, I've already taken you to the decision of Mr. Justice Hobhouse in the Turinia case, in which, in a Hague Rules case, he adopted the bailment analysis to burden of proof, and I don't need to go back to that. There are two additional judgments of, firstly, Mr. Justice Hobhouse and then Lord Hobhouse as he had become in the supplemental authorities, which I hope you have. First is at tab 2. Case involving the Mechanik Evgrafov and the Ivan Durbanev, and the passage concerning the burden of proof is on page 20 of the supplemental volume, internal 636. And there's a paragraph at the top of the left-hand column, which again sets out the bailment burden of proof and in the Hague Rules context. Since under these liner bills of lading it was responsibility of the carrier to load and discharge the goods, and since it was admitted by the carrier that he'd received the goods undamaged and had redelivered them damaged, the burden of proof lay upon the carrier to excuse himself from liability for that damage. Frankly, it's treated as being a statement of the obvious, that the bailment burden of proof continues to apply even in the Hague Rules context. And there's a very short observation to the same effect in the House of Lords decision in the Star Sin, which is at tab 7 of the bundle. It's at pages 127 to 128. Volume, internally 776 to 777. This, of course, was a case where the principal issue was who the contractual carriers were, whether the bills of lading that were issued were to be treated as owners' bills or charterers' bills. But in relation to the position as between claimant cargo owners and ship owners, at 137, Lord Hobhouse notes that there was a bailment on terms, or sub-bailment on terms, by cargo owners to the ship owners, and the relevant terms were those to be found in the time charter, and the time charter stipulated that the Hague Rules were to be incorporated into the contract between the ship owners and the time charterers. So those are the relevant terms of the sub-bailment. And then 138, by way of comment, the cargo owners could, by relying upon the goods owner sub-bailee relationship, have put the burden on the ship owners to excuse their failure to deliver the goods undamaged. They didn't do that, and they relied on a Donoghue and Stevenson claim, and therefore the burden remained on them. But again, it's simply being treated as axiomatic that even in a sub-bailment into which the Hague Rules were incorporated, the bailment burden of proof. So, my Lord, that's what I want to say in terms of our positive case in relation to the bailment burden of proof. There are three authorities relied on by my learned friend, which he says point the other way at this stage of the analysis. The first is the Albacora, and that is in the first volume of the authorities, tab 2. This was a case involving the carriage of fish, and unbeknownst to either the cargo interests or the carriers at the time of shipment, the fish perfectly naturally contained a species of bacteria that caused the fish to spoil if the temperature rose above 41 degrees Fahrenheit. The ship was unrefrigerated, and therefore it was necessarily the case that carriage on the contractual vessel would result in the fish spoiling. The majority decision and reasoning is set out in the speech of Lord Reid, with whom Lord Guest and Lord Upjohn agreed. And the starting point is that the judge had found that there was no negligence on the part of the carrier. We can see that at the top of page, starting at the bottom of page 1305, top of page 1306. Quoting passages from the opinion of the Lord Ordinary, looking up at the bottom of the page, in the present case, the proof discloses that, in fact, it was the ship that was incapable of carrying this cargo safely to its destination at this time of year and on this length of voyage. There was no suggestion that the voyage took longer than it should have done. The appellants accept the finding that there was no negligence and do not suggest that the result in any other similar unrefrigerated ship would have been any better. So that is in the speech of Lord Reid, and therefore the majority speech records that the appellant accepted the finding that there was no negligence. And that's obviously important because it means that it was not a case which turned on the burden of proof at all, because a negligence had been disproved. The ratio of Lord Reid's speech concerns the meaning of properly in Article 3, Rule 2, and therefore is addressing a quite separate point. The claimants had argued that properly meant that refrigeration was required, even though neither party knew that refrigeration was required at the time of shipment, and that the contract was for carriage on a ship which had no refrigeration facilities, and that argument was rejected by the majority, who held that properly imposed an obligation to adopt a signed system in the light of all the knowledge which the carrier had or ought to have had about the nature of the goods at the time of shipment. And given that test, the carrier had adopted a signed system. So it's not a case about burden of proof at all. That finding in relation to the meaning of properly was sufficient to dispose of the claim because the carrier had established that it had carried the cargo carefully, because there was a finding that there was no negligence, and the carrier also established that it had carried the goods properly in the light of the knowledge which it had or should have had at the time of shipment. Lord Reid then went on to discuss the inherent vice defence, and we'll come back to this in the context of the inherent vice defence itself. But again, that part of his speech doesn't bear on the question of the bailment burden of proof, which is the first issue that we're looking at. In the speech of Lord Pearce, at the foot of 1311, he says that the Lord Ordinary held that the pursuers had failed to make out their allegations of negligence. The pursuers contend, however, that this does not amount to an affirmative disproof of negligence. And he then goes on to discuss that. And that's a passage on which my friend relies at a later stage of the argument in relation to the factual findings in this case. I just point out at this stage, since we're here, that it's a rather curious observation in the speech of Lord Pearce, given the frankly contradictory statement in the speech of Lord Reid, that the appellants accepted the finding that there was no negligence. There's a rather curious anomaly there, which I'm afraid we haven't been able to resolve. But certainly, as I say, the speech of Lord Reid is the majority speech agreed with by Lord Upshaw and Lord Guest. And then what Lord Pearce goes on to do is to consider the judgment of Mr. Justice Wright in Goss Millard. But the passage that he's discussing there is a passage in which Mr. Justice Wright had suggested, or appeared to suggest, that there was an obligation on a carrier seeking to rely on a Hague Rules exception, both to prove the exception and to disprove negligence. Now, if that passage is to be treated as a statement by Mr. Justice Wright that in every case, as a matter of law, a carrier has to both prove an exception and disprove negligence, then we would accept that it may go too far. Because we say our analysis is that the proper approach is that the carrier has to either disprove negligence and therefore prove that he has exercised the contractual degree of care, or prove one of the exceptions, not necessarily both. But it's not necessary to read the judgment of Mr. Justice Wright in that way, because the statements that he made were all in the context of the Article 4 Rule 2Q defence, which of course does require the carrier to disprove negligence. So I mean, seen in that context, they're not controversial, because plainly to prove the exception, it is precisely disproof of negligence that is required. But in any event, for present purposes, when we're looking at the first topic upon which I'm addressing you, which is the effect of proof of damage, none of this is relevant to that. This all comes in at a later stage, considering what the carrier has to do if it wishes to discharge the legal burden that we say is necessarily upon the carrier to exculpate itself. And again, later in Lord Pearce's judgment, discussing the meaning of properly and the dramatic effect that the cargo claimant's meaning of properly would have had, and the dramatic change that it would have brought to the law, Lord Pearce, at the top of 1313, notes that if there'd been an intention to dramatically change the law in that way, it would have been expressed in clear language. And that rather echoes the point that was made by Lord Steen in the context of shippers' liability for dangerous goods, that if the drafters of the rules had intended to make a very dramatic shift in the responsibilities and burden of proof issues, it would have appeared in clear language, which I say it doesn't in the rules. And then in Lord Pearson's speech, I should say that in Lord Pearce's speech, he also refers on 1312 to Bradley and Federal Steam Navigation, which of course was a case which applied the bailment standard proof, or bailment approach to burden of proof. And there's no suggestion that Bradley and the bailment approach to burden of proof are no longer good law in a Hague Rules case. Then in Lord Pearson's speech, he says at the very end of his speech in page 136, he says that the carrier does have to prove that the damage was caused by an accepted peril or accepted cause. And he says in order to do that, he may in a particular case have to give evidence excluding causation by his negligence. But that again, the penultimate sentence saying that the carrier has to prove that the damage was caused by an accepted peril or accepted cause is consistent with the bailment burden of proof, which we say applies. So we say that really, if one looks at the albacora in the round, there is nothing there which is inconsistent with our analysis at stage 1, which is that proof of damage discharges the legal burden on the cargo claimants and puts the legal burden on the carrier. And then my friend also relies on two Australian authorities, Gamlin and the Bunga Sharoja. In both of those cases, burden of proof was not an issue, and the justices say so expressly. There are various discussions as to how the burden of proof might operate, all of which are necessarily obiter, and which are not internally consistent in the cases as between different justices.
Can I just ask you, before we leave the albacora,
Yes.
the first, on page 1315,
Yes.
electronic, do you want to say anything about the first paragraph? Where Lord Pearson seems to be treating the proof of damage to the goods as merely placing an evidential burden on the carrier.
Yes, I beg your pardon. I should have taken your lordships to that. That's right. That paragraph can certainly be read consistently with an evidential approach, but then seems to be inconsistent with the sentence that I took you to at the end of the speech. And I accept that it is a feature of the authorities that there are passages here and there in obiter dicta which can be read as being consistent with an evidential approach. But when you stack up against those, the authorities to which I've taken you to, that show that when it actually matters, it's being treated as axiomatic, that the bailment burden still continues to apply. My submission holds good, that the weight of the authorities show that since the introduction of the rules, the courts generally have proceeded on the approach that the bailment burden of proof applies even in the Hague Rules context.
So what's said in that paragraph is simply mistaken.
What he says is at the foot of 1314, the first step is to ascertain what the prima facie obligation under 3.2 is. And he says it's not an obligation to achieve the desired result. In my submission, that analysis is incorrect because it looks at 3.2 in a vacuum, in the abstract. What we say 3.2 does is define the relevant standard of care in a Hague Rules case. And one gets the obligation to redeliver in a signed condition, not from 3.2 itself, but from the underlying bailment relationship, the underlying contract of bailment.
I see.
I mean, in essence, what is said at the bottom of 1314 and the top of 135, that is my learned friend's case. He says you look at 3.2, 3.2 is a positive obligation to take care of goods, and therefore there must be a legal obligation on the cargo claimant to prove breach. I accept that this passage provides some support for that, but frankly, it's pretty much the only passage in all the authorities that does. It's obiter. It appears to be inconsistent with what Lord Pearson himself says at the end of his speech. It's inconsistent with all the other authorities to which I've taken you to, and for the other reasons that I've outlined, it is simply wrong. Lords, that's what I want to say in relation to that first issue, what's achieved by proof of damage and the bailment burden of proof. The next issue is inherent vice and what the carrier has to do to prove the inherent vice exception. And if our analysis at the first stage is accepted, that means that at this stage of the argument, there is a legal burden on the carrier to prove the exception applies. What does the carrier have to prove to discharge that legal burden? Really, there's little, if anything, between us in terms of the definition itself. The real dispute is as to the impact that the definition has on the question of what the carrier has to show to discharge the burden of proving the defence. As to the definition, we've set out the key authorities in paragraphs 120 to 136 of our written case. They're broadly common ground, so I was going to take you simply to, in the first instance, to Lord Reid's speech in Albacora, so we can go back to that. It's volume 1.1, tab 2, and the relevant passage is at 1308. Lord Reid said, Article 4, Rule 2M provides that the carrier shall not be responsible for damage arising from inherent defect, quality, or vice of the goods. A number of authorities were cited, and perhaps the most concise statement is that of Mr. Justice Gorrell Barnes in the Bar Corps. This cargo was not damaged by reason of the shipowner committing a breach of contract or omitting to do something which he ought to have done, but it was deteriorated in condition by its want of power to bear the ordinary transit in a ship. By the ordinary transit, I would understand the kind of transit which the contract requires the carrier to afford. I agree with Lord President when he says Rule 2M is, in my opinion, intended to give effect to the well-settled rule in our law that if an article is unfitted owing to some inherent defect or vice for the voyage which is provided for in the contract, then the carrier may escape liability when damage results from the activation of that inherent vice during the voyage. And then it follows that whether there's inherent defect or vice must depend on the kind of transport required by the contract. And we say that the kind of transit which the contract requires the carrier to afford must mean transit in providing the standard of care which the carrier was required to afford. And the statement to that effect in Scrutton, which one can find in the authorities at volume 6, page 3513, is a fair and accurate summary of the law.
Is this in tab 94?
I'm so sorry, it's tab 94, page 3513. shipowner is not liable for loss or damage to the goods caused by inherent vice. By inherent vice is meant the unfitness of the goods to withstand the ordinary incidents of the voyage, given the degree of care which the shipowner is required by the contract to exercise in relation to the goods.
But there's an element of circularity about that, because the degree of care which is required to exercise is going to depend, among other things, on the known characteristics of the cargo. And there may be some cargoes which no degree of care, type of activities, get safely to their destination. Basically, there isn't a standard, there isn't a single standard of care applicable generally to all cargoes.
That's right. But the standard that applies in a Hague Rules case is the Article 3, Rule 2 standard, which is that the carrier has to properly and carefully carry the goods. And the important point we say is that there are two elements to the definition. It's not just a question of the deterioration in the goods arising out of something to do with the goods themselves, some inherent nature of the goods. One also has to bear in mind that it's the unfitness of the goods to withstand the incident's voyage, given their inherent characteristics, but supposing that they have received the contractual degree of care to which the cargo is entitled. And you can't, I'll develop this point in a moment, you can't simply say that because the deterioration is something to do with the goods, that's the end of the inquiry. The definition necessarily requires you to look at the standard of care which has been provided and to consider whether the reason why the goods have deteriorated is because they haven't received the standard of care to which the cargo owners were entitled by the terms of the contract.
The question is whether the goods have a characteristic which makes the deterioration unavoidable.
Yes, indeed. I mean, we do say that there are two ways in which the carrier can exculpate himself when it comes to inherent vice. One is to show that he, in fact, exercised the requisite degree of care required. In the Hague Rules case, that he properly and carefully cared for the goods. But despite that actual proven provision of contractual care, the goods deteriorated nonetheless as a result of an inherent characteristic. The other way in which he can exculpate himself is to prove that whether or not he provided the requisite degree of care, the damage was unavoidable or inevitable. So that there are two routes by which he can exculpate himself.
Does the first of those submissions give support to your submissions in relation to the first issue, as to the scope of or the meaning of Article 3, Rule 2?
It's certainly consistent with it.
Yes.
I mean, we say that what Article 3, Rule 2 does is define the contractual standard of care, and therefore to exculpate himself. As I say, the carrier either has to prove that he's done that, or prove that an exception applies. And what it does do is tie in with the issue as the extent to which some of the exceptions are truly freestanding exceptions, as opposed to simply being a mirror image of the duty of care under Article 3, Rule 2. And if one looks at it, there's a very strong case for saying that Q is simply the flip side of Article 3, Rule 2. And the judge, at first instance in this case, saw the inherent vice exception as essentially being another flip side of Article 3, Rule 2, it being necessary to prove that the carrier had exercised reasonable care in order to prove inherent vice. I say our analysis is that there are two ways in which the carrier can exculpate himself in a case in which he's essentially relying on inherent vice. One is to prove that he provided contractual care, but the goods deteriorated nonetheless as a result of an inherent characteristic. The alternative is to prove that whether or not he provided reasonable care, the damage was unavoidable or inevitable.
The way Lord Reid, just before he deals with this, has dealt, as you took us to this passage earlier, with what's meant by a sound system in terms of proper practice for the purposes of Article 3.2 at the foot of 1307, and relates it to the knowledge which the carrier has about the nature of the goods.
Yes.
And if he has no reason to suppose that they require different treatment from the treatment he actually gives them, then he's clearly nonetheless complied with Article 3.2. But the fact that the goods required a different treatment could constitute an inherent vice because they wouldn't be able to withstand the transit contemplated by the contract.
By the contract, yes, that's right.
But if, for example, the only way that the goods could survive intact to their destination was to have a refrigerated vessel.
Yes.
This was not a refrigerated vessel.
Yes.
The contemplated standard of carriage would be that appropriate to an unrefrigerated vessel.
Exactly, yes, yes.
That's effectively the facts of albacora.
It's the facts of albacora, and holding that when construing the standard of care required by Article 3, Rule 2, and in particular what properly means, you don't look at an absolute standard. You look at the standard that's required in the light of the knowledge which the carrier had or ought to have had about the goods.
It also enforces the point that an inherent vice, you have to read the whole phrase. The goods don't have to be defective. They may just have requirements for carriage of which the carrier is reasonably unaware.
Yes, but
Supply.
Yeah.
yes, exactly. The other side of that coin is that there are goods which may deteriorate if they don't receive proper and careful carriage. And of course, we say that's precisely this case. Coffee beans being transported from South America to Northern Europe will suffer condensation damage if you don't properly and carefully line the containers so as to absorb the condensation which inevitably forms. But it's not enough to discharge the burden of proof in relation to inherent vice just to say the cause of the deterioration emanated from the goods themselves. You have to ask the question, would the damage have occurred if they had been properly and carefully carried? And then when you get to that stage of the question, as I say, the carrier has two options. One is to demonstrate that he did properly and carefully carry the goods, but we say the legal burden is on him to do that on the balance of probabilities throughout, or to prove on the balance of probabilities that exactly the same damage would have occurred, whether or not he provided that standard of care.
And there is very considerable overlap, Mr. Russell, isn't there, between Article 3.2 and the defence under Article 4.2, forget Q, even M, because the defence under Article 4.2M is the carrier shall not be responsible for loss or damage arising or resulting from ... inherent vice. And so put on one side, well, whether the carrier has a legal duty to establish this or simply to raise a prima facie case about it, he's got to show, hasn't he, that the damage didn't arise or result from the damage arose or resulted from inherent vice. And that's what Lord Pearson was saying at the end of his judgment.
Yes,
if in fact it arose or resulted from his own negligence, then he can't get home.
Exactly.
And so those words arising or resulting from at the beginning of number 2 really do bring in, don't they, the whole question of causation, and whether the causation was as a result of his negligence, and whether the causation was as a result of his failure to comply with Article 3.2. Is that roughly right?
Yes, exactly. That's how we put it. Mm. And there is, I mean, one can quibble over whether the judge went too far to say there was complete circularity between 3.2 and 4.2m or not, or whether there was not complete circularity, but there is certainly a very high degree of overlap. That's not surprising that should be the case, given the legislative history of the rules and the way in which the exceptions came to be there. I mean, it's not surprising if one looks at other of the exceptions where, for example, act of God, the exclusion of negligence is an inherent part of the definition of act of God. And therefore, it can certainly be said that there's complete or near complete overlap between 3.2 and the act of God exception. See Nugent and Smith, which is in the core volume of authorities to support that proposition. And it's the same point is made in Carver. So the independent degree of life that the exceptions have differs from exception to exception. I mean, we would say that there is obviously no independent life to Q, because Q is simply a mirror of 3.2. And there is, perhaps it might be said, very little independent life to M. But there's no surprise in that. But the important point is that if we're right at the first stage, then there's a legal burden on the carrier to prove every aspect of the defence.
Even Q.
Yes.
Yes.
But in relation to M, as Lord Pearson said, and was echoed by Mr. Justice Hobhouse in the Terrania, practically, for the carrier to prove the exception on the balance of probabilities, he's going to have to prove that either that he provided the requisite degree of care, or that damage was inevitable. And there's nothing, given the wording, as Lordship says, of the article, there's nothing surprising or controversial in that.
So is Lord Justice Aikins in his book right to say there's some difficulty about the first part of Article 3.2, subject to the provisions of Article 4? Because you get the impression that Article 4 prevails over Article 3, but when you pick it through, that's not at all the position.
Yes. The Aikins book, I think, prefers an evidential approach to 3.2, which makes life more difficult.
I don't think this is an evidential point. This is a construction point, really, Mr. Russell. Anyway, there we are.
I mean, what all the textbooks do is note the lack of heterogeneity in the exceptions. There's no particular logic to them, nor one would expect them to be, since they essentially reflected a collection of exclusion clauses that owners had introduced at common law, which had grown by a process of accretion, and which were then massaged to a certain extent by the drafters of the rules. So one's not looking for, and one shouldn't expect to find an entirely internally cohesive and coherent drafting of the rules. And that's one of the reasons why we say it's not at all surprising that you have that degree of overlap between 3.2 and M, in the same way as you do between 3.2 and the act of God exception, or 3.2 and Q.
Yes, that would be consistent with your earlier point about it being only a partial harmonisation. So they were trying to put a limit on what the carrier could write into the contract.
Yes.
So it was looking at what carriers had already written into the contract and seeing which of them were acceptable.
Yes, indeed. And looking to see which of them were acceptable, and also looking to see which of them had to be included to prevent British ship owners throwing their hands in the air and saying we're never going to agree to
Well, acceptable, and that's what I meant, acceptable
yes.
for that reason.
Yes, exactly, yes. I mean, I don't think anybody would suggest that if you were going to devise a cohesive and coherent set of rules for carriage, you would take the starting point that the drafters of the rules felt they were obliged to take. there we have it. The important point, as I say, is that if we're right at stage one, and the legal burden is on the carrier, he's got to prove all the aspects of it. And we've seen what both Lord Pearson in Albacora and echoed by Mr. Justice Hobhouse in Trinia say that requires when you come to inherent vice. And this doesn't turn on what Mr. Justice Wright said at first instance in the Goss-Millard case. The criticism of Mr. Justice Wright at first instance in Goss-Millard has been that he went too far, in fact suggesting that in every case under the rules, the carrier had to prove an exception and disprove his own negligence. We don't say that. We say what we're doing here is looking at the inherent vice question. And the issue is not, is there some sort of overarching principle that a carrier always has to disprove negligence before he can rely on an exception? The question is, what does a carrier have to do to rely on the exception that he seeks to rely on in a particular case? In this case, it's inherent vice. What does the carrier have to do? We'll see Lord Pearson in Albacora, see Mr. Justice Hobhouse in the Trinia. Now, I'll not take you to Nugent and Smith, but we've set out the relevant passages in our written case, and also passages in Greenshields and Lister, which again make good the point that in certain circumstances, to rely on an exception, in particular inherent vice or act of God, it's going to be incumbent on the carrier in practice to negative negligence. What I want to do now is to look at the Court of Appeal's error in relation to inherent vice. And we can trace the error in the judgment in this way. I've taken you already, first of all, it's in the appeal documents bundle. Starting at electronic reference 218. And I've taken you to paragraphs 35 and 36 already, in which we say the Court of Appeal correctly identified that proof of damage puts a legal burden on the carrier to prove that an exception applies. The error, we say, starts to manifest itself in paragraph 37. Now, we're still in a section of the judgment which is headed the operation of burden of proof under the Hague Rules generally. And what the judgment says is, the critical question is whether, in cases to which the Hague Rules apply, a necessary part of establishing the application of the exception, here the exception in Article 4, Rule 2M, that the carrier establishes that the damage occurred without its negligence, or notwithstanding that it properly and carefully carried the goods, or whether, in accordance with the principles laid down in the Glendarach and the cases that have followed it, Mr. Bryan's third stage is then reached, and the legal burden is on the cargo claimant to negative the operation of the exception by establishing negligence or want of care on the part of the carrier. Now, the first error is that this discussion is taking place in a general section of the judgment dealing with burden of proof under the Hague Rules, rather than the later section, which deals specifically with the inherent vice defence. Because we say that there's no one-size-fits-all answer when it comes to the question of proving or disproving negligence under the various exceptions. What you have to do is look at the individual exceptions and the particular exception that's being relied on and see what is required to discharge the legal burden of proof in relation to that particular exception. But there's an internal error in this paragraph in any event, because the first part of the paragraph asks a relevant question. At the second stage, what does the carrier have to do to discharge the legal burden? It's asking it in the wrong place, because it should be asking it by reference to a particular exception exclusively, rather than looking for a general one-size-fits-all answer. The second part of the paragraph goes wrong when it says whether, in accordance with the principles laid down in the Glendarach, Mr. Bryan's QC's third stage is reached. But the first part and the second part don't match up. The third stage can only be reached if the second stage legal burden of proof has been discharged by the carrier. If one applies a proper legal burden approach to it, first stage is proof of damage. Second stage is proof of all the matters by the carrier that it has to prove the exception. And then third stage, on Glendarach principles, is a legal burden on the claimants to prove an exception to the exception. So there's no logic to the way in which this paragraph is formulated. And having raised but not answered the relevant question in the first part of paragraph 37, the judge then goes on to look at the Goss-Millard decision and the authorities which have considered it subsequently. But those are all relating to what happens at the third stage. Is there a third stage where the carrier has to also does the carrier also have to disprove negligence, as perhaps could be suggested by Ms. Justice Wright's decision in Goss-Millard? Or, to the contrary, does a Glendarach approach apply, and there's a legal burden on cargo claimants to prove an exception to the exception at the third stage? Mr. Bryan's third stage is that if the carrier has proven an exception, there's a legal burden on the cargo claimants to prove an exception to the exception. So what happens is that effectively in paragraph 37, the judgment slides from asking the relevant question, which is what does the carrier have to prove to discharge the burden, to a discussion as to what happens at the third stage. And that then infects the later part of the judgment, when the court really re-asks the question, what is required at the second stage. And one looks at paragraph 42. One sees a further manifestation of this error or mistake. The judgment says the submission of Mr. Bryan that once the carrier has shown that the loss apparently falls within the inherent vice exception, at the third stage the burden then shifts back to the cargo claimant to disprove negligence, is also supported by and sets out various authorities. But what you've got to remember is that the carrier's case, Mr. Bryan's case, was predicated on his argument that the burdens at stage 1 and stage 2 were merely evidential burdens. So that's why his case was that the carrier only had to show that the loss apparently fell within the inherent vice exception. What the court hasn't done is carry through the consequences of its correct decision that there's a legal burden on the carrier at the second stage. So having made that right decision, because of the...
Or that decision was wrong, as your opponent will say.
Yes, well, yes. I mean, if they're actually wrong about...
But you say this is internally inconsistent.
It's internally inconsistent, yes. It is. And the explanation for it can be found, I say, in paragraph 37, where you have that sort of slippage from posing the right question to moving on to third stage without answering the key question. And then, in a sense, 42 answers the question that was posed in the first half of 37, but it answers it incorrectly. It can only be right if the Court of Appeal had reached the different finding at 35 and 36 from that which they did, which they plainly didn't, because they plainly analysed it in questions in terms of a legal burden.
Why is the judge in 42 talking about the cargo claimant disproving negligence? I would have thought, if he's right, the cargo claimant needed to prove negligence, didn't he?
Disproves is a
It's
typographic error.
Yes.
Oh, is it?
Yes, it is. Yes, I'm so sorry. I should
It should just be prove.
Yes.
Oh, right.
Yes.
Because if you look at the passage below from Scotland,
Right, thank you.
Yes. Yes, no, and we can't blame Mr. Rainey, but we can blame everybody else on the front bench. We failed to pick that up whenever we were approving the draft judgment. But it's wrong, paragraph 42, because if the burden at the second stage is a legal burden, you can't discharge a legal burden by proving that the loss apparently falls within the inherent vice exception, whatever that means.
Well, you're having great fun with this, aren't you, Mr. Russell? First of all, the Court of Appeal says there's a legal burden, and then it's all back to inferences and prima facie cases. We accept that you can have fun with that, but Lord Kitchin has just pointed out that the premise may be wrong.
Yes.
Legal burden.
Yes. But well, I've developed my submission as to why we say it's not. I don't want to go with that grind. It's why that first stage of the analysis and the bailment burden is important. That's why I've spent some time on it. The Court of Appeal were persuaded by that, but perhaps because of the focus that was, we say, a misplaced focus on the Glendarroch, because it's dealing with a different exception. The Court of Appeal has I mean, any appellant here is going to say that the Court of Appeal has gone wrong somewhere, and this is where we say the Court of Appeal has gone wrong, because having correctly made a decision in relation to the nature of the burden of proof on the claimant, I beg your pardon, on the carrier, they have failed to follow through on their own logic.
Can I just ask Mr. Russell how you are doing for time, because you still have Glendarroch and all the factual questions to come to.
Yes, I'm not doing as well as I would like, but probably not too badly.
Well, we can try to curtail the number of interruptions.
I'm not going to develop orally our submissions in relation to the Glendarroch, because we say it's not relevant to the inherent vice defence. It's dealing with a different defence.
Yes. Well, yes.
Until 2:30.
Yes. We'll just carry on then.
I'm grateful. Yes, and so the error that we see in 42 is then continued after the discussion of the authorities at paragraph 50, where the judge says, in my judgment, the correct analysis at Mr. Brown's third stage is that once the carrier has shown a prima facie case for the application of the exception of inherent vice in Article 4, Rule 2, the burden then shifts to the cargo claimant to establish negligence on the part of the carrier, such as will negative the operation of the exception. But again, implicit in that is a finding that to discharge the legal burden at stage 2, all that the carrier has to do is to show a prima facie case for the application of the exception. That is the error. If our overarching analysis is right, then at stage 2, what the carrier has to do is to show that on the burden on the balance of probabilities, the exception applies. And again, it comes back to Pearson and Albacora and so forth. And the other error that we say that emerges both in this section and the subsequent section, which looks at inherent vice, when one reads the decision, is that the Court of Appeal, when they say a prima facie case for the application of the exception, or loss apparently caused by inherent vice, seem to have in mind simply that it's something to do with the cargo itself. In other words, something to do with an inherent characteristic of the cargo. And as I indicated earlier, that's only half of the definition. The reason why Lord Pearson said what he said in Albacora is because identification of whether or not there's been inherent vice, when one looks at the definition, doesn't depend on just saying that the deterioration has had something to do with the goods or emanates from a characteristic of the goods themselves. It necessarily involves an analysis of what the contemplated voyage was and what the nature of care was that was required by that contractual standard of care. And therefore, even at a prima facie level, you have to look at both parts of the definition, not just one. And so for the avoidance of doubt, for this reason, we do say that even if we're wrong at the first stage of the analysis and the question of whether it is a legal burden or not at the second stage, even if we're wrong about that, the Court of Appeal's decision is flawed, because even to show a prima facie, to show that apparently the loss was caused by inherent vice, you still have to look at both parts of the definition. It doesn't even raise a prima facie case of inherent vice to say, well, the goods deteriorated because there was moisture in the goods. You've still, at that stage, got to ask whether there is a prima facie case that if they had received the contractual degree of care, the same damage would have eventuated or not. Notice, I fear that if I develop those points in relation to inherent vice any further, I'll be repeating what I've already said. I think I've covered the points that I wanted to make in answer to your Lordship's questions. The Glendarach, as I say, I'm not proposing to address you on the Glendarach unless you wish me to. We've set out our arguments in the written case as to why we say, even on its own facts, it was wrongly decided and shouldn't be followed. But it's just not applicable in the circumstances of this case, because you have to look at the inherent vice defence and what's required to prove the inherent vice defence on the balance of probabilities. So that leaves the facts of the case and the disposal of the appeal. And the starting point is that if we are right on the law, then the carrier can only avoid liability if they prove that they properly and carefully carried the goods. And obviously there are two elements to that, both properly and carefully carried the goods. Or that they prove that all of the damage that occurred was caused by inherent vice. And as I've said, to do so, they have to prove either that they properly and carefully carried the goods, but the loss happened anyway, or that, whether or not they properly and carefully carried the goods, all the damage was unavoidable or inevitable in any event, and thus was caused by inherent vice and not by their breach of the standard of care in Article 2. And we say that there's simply no findings of fact in either judgment which discharge the burden that's on the carrier. As a starting point, we say that it's plain on a fair reading of the judgments that both the judge and the Court of Appeal decided the case on the basis of burden of proof, certainly in relation to the question of whether the carrier had properly and carefully carried the goods. A fair reading of the Appeal's decision is that, just as the judge did, it decided the case on the burden of proof, and it reversed the judge's decision because it held that at the third stage there was a burden of proof on the claimant to prove negligence as an exception to an inherent vice exception, and that the claimants had failed to do so. If I can take your lordships to some of the key passages in the judgment to make that good. At paragraph 52,
This is the deputy judge now.
Lord, no, this is
Court of Appeal's judgment.
I'm so sorry.
Appeal. No,
Yes,
it's my fault. It's my fault.
I don't think there's any dispute that the deputy judge decided the case in the claimant's favour on the basis of burden of proof. He held that the carrier had failed to discharge the burden that was on it. The submission that I'm developing now is that the Court of Appeal also disposed of the case on the basis of their analysis of burden of proof, having identified a burden of proof on the claimants to prove negligence. Paragraph 52, at electronic reference 237, judgment says it's worth pointing out that the number of cases where the result turns upon the shifting burden of proof, as opposed to the evidence demonstrating one way or the other whether the carrier is liable, must be limited. The burden of proof is only of significance in the present case because of what is, on one view, the failure of the judge to make clear findings of fact in relation to the issue of negligence. Accordingly, the question whether the burden was on the carrier to disprove negligence in order to establish an entitlement to rely upon the exception, or upon the claimants to prove negligence of the carrier in order to negative the application of the exception, became of critical relevance in this case in a way which is atypical. So the Court of Appeal identifies the burden of proof as being of significance and indeed of being of critical relevance. They don't suggest that it has ceased to be of critical relevance because they have made findings of fact of their own, which render the burden of proof no longer critical or no longer of supreme importance. If the Court of Appeal had thought that that they themselves were making findings of fact, which meant that their analysis of burden of proof was obiter or no longer of importance, one would have expected them to have said so in clear terms. And similarly, at the very start of the judgment, in fact, in paragraph 1, we see that the case is introduced on the basis that it raises a series of issues of principle in relation to the scope and operation of the Hague Rules. Although it involves small amounts of money, it's been treated as something of a test case. There's nothing to suggest that the issues of principle have in any way fallen away as a result of factual findings made by the Court of Appeal, which mean that those important issues as to burden of proof are no longer deciding factors. Similarly, one can see that at paragraph 32, in terms of the way in which the Court of Appeal summarised the issues before it, all the issues that the Court of Appeal identified were issues of law. rather than issues of fact. So there's no suggestion there that the Court of Appeal was going to, or had disposed of the case by reference to findings of fact made by the Court of Appeal themselves, rather than the legal issues that they identified as being the issues in the case.
Well, I see what they say there, but then later on, Lord Justice Flo says that, I mean, putting it very shortly in what may be a contentious way, he says, I'm satisfied that there was a general industry practice and that it was followed, and I would dismiss the appeal on that ground. I would allow the appeal on that ground. And then he goes on also to say that I find that minor condensation damage is inevitable, and I would allow the appeal on that ground also. Yes.
Yeah. Well, he does, and I'll deal with both of those points, obviously. Undoubtedly, there were findings of fact which were made by the Court of Appeal, which are contrary to findings of fact made by the judge. I'm setting the scene here in terms that the decision at first instance turned on the burden of proof.
Yeah.
And certainly the thrust of this part of the judgment is to similar effect. What we say is that, I should have seen it from my written case, and I'll develop these submissions now, even in the light of those findings of fact that were made by the Court of Appeal, the cargo claimants don't have the necessary findings of fact to discharge the legal burden which is on them. And in any event, and furthermore, the Court of Appeal wasn't entitled to interfere with the judge's findings of fact, or perhaps more accurately, non-findings of fact in relation to those issues. It's not a case in which the appellate court was entitled to intervene in the way in which it did. It's interesting that the way in which my learned friend puts it in his written case, actually, is to say that a finding that one party fails to prove X doesn't equate to a positive finding, does equate to a positive finding that X did not happen. So in other words, the CSAV's primary case in relation to this issue really follows the burden of proof analysis. They don't seek to point to particular findings of fact that get them home. They say that a finding by a lack of proof one way must constitute proof the other way. And we say that that is simply wrong. Where you have two competing theories as to why damage occurred, so in this case, inherent vice, even though contractual care was provided, or failure to provide contractual care on the other hand, a perfectly acceptable outcome is for the court to say, well, on the evidence, I'm left in doubt. Neither of those explanations has been proved on the balance of probabilities, and therefore the case has to be decided by reference to the burden of proof. And we've put the Poppy M in the bundle. It's not a case that's going to take any of your lordships by surprise. The relevant passages are at 954F, 955H, and 956, which are at pages 60 to 62 of the supplemental volume. What was made very clear in that case is that it's always open to the court to find that a matter is left in doubt and has not been proven by either party, and that therefore the burden of proof analysis becomes crucial and dispositive. Now, the error on this point that the carriers make is their reliance on a passage in the case of In Re B, which they cite in their case at paragraph 204. written case, this page, page 198 of the electronic bundle. Hoffman said, if a legal rule requires a fact to be proved, a judge or jury must decide whether or not it happened. There's no room for a finding that it might have happened. Well, that's right, but there's always room for a finding that it hasn't been proven on the facts either way. The law operates a binary system in which the only values are 0 and 1. The fact either happened or did not. If the tribunal is left in doubt, the doubt is resolved by a rule that one party or the other carries the burden of proof. If the party who bears the burden of proof fails to discharge it, a value of 0 is returned, and the fact is treated as not having happened. You have to read that, though, with the Poppy-M decision. And in a forensic setting, it's perfectly possible that the figure that is entered for both it did happen and it didn't happen is 0. If neither side discharges the burden of proving it one way or another, you can have 2 zeros entered. And the outcome of the case then depends on who bears the burden of proof. It's the rule of, or the sign of 4 error to say that a judge has to enter a 1 somewhere in the analysis. A perfectly acceptable outcome is for the judge to say, nobody has satisfied me as to the cause of damage in this case, even where there are only 2 options in play. There were only 2 options in play in the Poppy-M, a wear and tear theory and a mini submarine theory. The House of Lords said it's possible to say that neither side has discharged the burden of proof in relation to its theory. Similarly, in the Joseph Travers and Cooper case, which is in the authorities' bundles, there were only 2 theories in play as to why the barge was lost, a mud-sucking theory and underpinning theory. And in the Court of Appeal, it was pointed out that on the evidence there was simply uncertainty as to which was the cause. Neither cause was proven, and the case therefore turned on burden of proof. So a non-finding does not mean that there is a positive finding the other way, and the carrier's argument in that regard is simply wrong. Now, it's also important in this regard to look at a further paragraph in the judgment in the Court of Appeal. If I can take you to paragraph 92 of that judgment. This, I should have taken your lordships to this a little bit earlier in my submissions, because it does go directly to the question of on what basis did the Court of Appeal decide the case, certainly at least in relation to properly and carefully. Judgment says, in my judgment, if the judge had applied the law in relation to what constitutes a sound system and the burden of proof correctly, he would have concluded that the claimants had failed to establish that the carrier's system of lining the containers was not a sound system. And in those circumstances, the carrier's defence under Article 4, Rule 2M succeeded. I would allow the appeal on this ground. So what Mr. Justice Flo is saying, giving the judgment of the Court of Appeal, is not that the appeal is allowed on this ground on the basis of a positive finding that the carrier had discharged the burden of proof on it. He's saying that if the judge had applied the law properly, he should have found in the carrier's favour because the cargo claimants had failed to discharge the burden of proof on them. And that ties in with my earlier submission that the Court of Appeal, certainly in relation to properly and carefully, were themselves deciding the case on the basis of the burden of proof. Saying in pretty clear terms, what the judge should have done is found that the cargo claimants had failed to discharge the burden of proof on them, not make a positive finding that the carriers had discharged the burden of proof on them, if there's a legal burden at stage 2 to prove that the exception applies. Lords, it shouldn't come as a surprise that this case, certainly in relation to properly and carefully, ultimately turns on the burden of proof. Because the carriers never pleaded or sought to prove what weight of paper or card they thought should have been used, or what weight of paper or card they said was required by any industry practice in relation to the carriage of coffee beans. And they didn't adduce any witness evidence from anyone involved in the stuffing of the containers to explain how or the degree of care with which the lining of the containers was carried out. I mean, it's a slightly curious feature if one looks at the pleaded case that the carriers went to trial on. Just very briefly, the defence is at tab 3, volume 2 of the appendix. If one picks it up at 344, they admitted that they were aware that during the transportation of containerized cargoes, condensation can develop. But they denied that they were aware or ought to have been aware of the effect of such moisture on coffee and or the customary manner in which cargoes of containerized coffee were packed. They denied that they were aware or ought to have been aware of the particular qualities of any particular cargo or the customary manner in which any particular cargo was to be packed. And they plead over the page at 346 and 347 that at 17.2 they were entitled to and did treat the cargoes in a manner appropriate to ordinary goods. This included lining the containers with sufficient craft paper to protect ordinary goods against damage sustained as a result of ordinary levels of condensation. So, as I say, in circumstances where the carrier's own pleaded case was that they were entitled to treat the cargo of coffee as if it was any old cargo, and they positively aver that they used sufficient craft paper to protect ordinary goods against damage as a result of ordinary levels of condensation. It's not at all surprising that they find a case decided against them on the basis of application of a burden of proof, where they have to show that they properly and carefully cared for the particular cargo, which was a cargo of coffee beans. Lords, I see the time. I'll go into the analysis of facts in a little bit more detail in my remaining half hour. If that's a convenient moment, then.
Yes, thank you very much.
Will you at 2 o'clock have a legible copy of the bill of lading?
I sincerely hope so.
I think there is a legible copy added in the supplemental
Ah, well, that's helpful.
at tab 9, which has the front of the bill at least.
Yes, it has the front. I think we've got a copy of the back, if your lordships would like a copy of the
Yes, we have a copy of the back.
That's the supplemental, I see.
Yes.
Yep, no,
It's
yeah,
just
that
the front
that looks
page.
perfectly legible to me. But where do you say the back is?
The back, the back, we've got the back here, and we can get the
Right.
back to you. In fact, we can probably get the
I
back to
could
you
have
now.
that at 2 o'clock as well.